On the 20th of April 2012, Ched Evans was convicted of rape. He was a promising striker playing for Sheffield United, and now questions exist about whether he should be allowed back into football, having recently been released. I hope that you watch Messy Seconds, this channel, to form an opinion about football, not just get mine. Having said that, in this particular video, I'll explain the case and what could happen now as best I can, but since it's such an emotive issue that I feel really strongly about, I'll also be giving my opinion at the end. There'll be two parts to this video. The first part will be talking about what should happen now, assuming he is guilty, and the second part will break down the assumption that perhaps he's not guilty, and so I'll be going through the actual case. So, should Ched Evans be allowed to work again in football? The yes argument, assuming his guilt, centres on the rehabilitation of criminals. Having served his sentence, does he not deserve to find employment in his chosen field? If no, what message does this send out to current or even potential convicts? What's telling those who have made criminal mistakes to get back on track if we as a society don't provide them with the opportunity to do so? Those who want him to return to football might point to his lack of remorse for the terrible crime he committed, but how can he apologise if he genuinely believes his innocence? With further convicts so often turning to drug-related illnesses, further crime, etc. when denied proper rehabilitation, is a very genuine and valid concern. If he is rehabilitated to football, his life will never change back to normal. Fans of opposing teams will chant about his crime until he retires. He will permanently feature on the violent and sex offender register. If he sets a bad example to children, is that not the fault of our education system for failing to tell them otherwise? Those that think he shouldn't work in football again say that the idea he deserves to earn a living or have a right to employment is rubbish. Being a footballer is not just like any other job. It comes with added responsibilities and it comes with added benefits. This isn't just a guy who doesn't have enough money to live. Arguing for his re-employment in football may essentially be arguing for his right to a highly paid hobby with many perks. Regardless of what he or anyone else wants, he would be a role model. You can't argue that rehabilitation would potentially turn around his life because he doesn't feel like he's done anything wrong in the first place. He has no remorse. Should rehabilitated role models not work on the basis that the person is looking from their mistakes and actively looking to improve themselves as a person? It's true that the law states that convicted criminals have a right to rehabilitation, but no one has the right to return to their chosen fields. Certain fields, with certain privileges, do not employ ex-cons, including teachers, MPs, the medical profession and law. Is football not a position of extreme privilege? Football is surely a field much like the previous list that children look up to and are influenced by. But arguing that Ched Evans was wrongly accused of rape is an entirely different matter. It undermines everything else we've said. But it may be a valuable discussion, for of course if he was wrongly convicted, then arguments about his remorse, rehabilitation, jail time, etc. become almost irrelevant. The case begins without any doubt for the fact that both Ched Evans and his friend Clayton MacDonald had sex with a 19-year-old woman on the night of the 29th to the 30th of May 2011. The issues for the jury were whether she could have consented, or either of the men could have reasonably believed she consented, and the possible relevance of her alcohol consumption. It's worth mentioning that the rape case began after Evans admitted having sex with her. The woman didn't make the claim because she didn't remember what had happened. Some people may say that it therefore shouldn't be a rape case, which is obviously ridiculous, since if anything, the fact that she was drunk enough to not remember strongly points towards a lack of consent. Between midnight and 3 AM of that night, the woman drank alcohol, had a shower at home, went to a bar, drank vodka and left the bar. She said that she did not remember leaving the bar, however had vague recollection of a kebab shop. CCTV footage shows her at both places. In the kebab shop, she is seen clearly drunk, unsteady on her feet and falling over. Furthermore, she had left her handbag in the shop. On this evidence, the prosecution state that she was very drunk. Evans and MacDonald had spent the evening with friends at various licensed premises. At 4 AM, MacDonald, who remember is also on trial for rape, meets the woman. They have a conversation in which he says he's going to his hotel and she says that she'll go with him, so they get in a taxi. The driver notices that her clothing is messed up, more evidence of her drunken state. MacDonald texts Evans saying he's got a bird, he says in case Evans wonders where he's gone. The prosecution say they were both on the lookout for a suitable woman or women to have sex with, explaining why the room was booked. Evans himself claims that the room was booked for MacDonald and a friend to stay. The woman in question had no recollection of events after 3 AM. The night porter described her as extremely drunk. She says to MacDonald, "You're not going to leave me, are you?" before they enter the room in which various sexual acts take place. MacDonald says that she initiated sexual activity, was enthusiastic and was enjoying herself. He did not make her do anything that she did not want to do. In response to MacDonald's text, Evans arrives at the hotel with 2 friends. The night porter gives him a key on the basis that he booked the room. Evans later admits lying to the night porter to obtain a key, doing so because he is aware that the hotel has a policy of multiple occupations of rooms. He enters the room, MacDonald and the woman stop having sex. Evans and the woman then have oral and penetrative vaginal sex, which he claims she consents to. During this, the porter checks the room but doesn't go inside because he can quite clearly hear sex noises. MacDonald leaves the hotel, telling the porter to check on the woman because she was sick. Evans instead left via the emergency exit. The woman's next memory is waking up the next morning at 11:30 AM, realising she was alone, naked, and had urinated in the bed. She has a headache and is confused, so she reports the matter to the police. Various samples are later taken, no alcohol is detected, but that's probably because of the time gap in reporting. The doctor finds no injuries, though she has taken some cocaine and cannabis a few days before the night in question. The expert hired by Ched Evans said that her alcohol consumption was high, around two and a half times the driving limit, but that despite expecting slurred speech and unable walking, he would not have expected memory loss. Ched Evans is then brought into question, saying that he had both oral and vaginal sex with her, but that she consented. The jury found MacDonald not guilty, but Evans guilty. You might say, as Evans' counsel did, that if MacDonald is found not guilty, then there isn't a sensible basis to find Evans guilty. The court argues firstly that they are different cases. The period in which Evans is accused of raping the woman is not the period in which MacDonald is, and therefore there's no inherent inconsistency since the evidence was not identical. It is argued that MacDonald could reasonably have believed to have gained consent, though in his separate trial Evans could not. Either way, the court decided that there was no inconsistency and that both cases would be up to the jury's decision. The next criticism of the decision was that a drunken consent is still a consent, and that her lack of memory of the events bears little to no relevance for her consent. The judge replied that she could consent if and only if she has the freedom and capacity to make a choice, and she exercised that choice to agree to sexual intercourse. He continues, this time it's not an exact quote, but me paraphrasing, that an individual who is intoxicated is disinhibited, which removes their capacity to exercise a choice. In a state of lesser awareness, that state must be taken into account when deciding whether or not she's capable of that choice. Extra information later came forward that the woman had on several previous occasions stated to friends that having had a lot to drink, she often had no recollection of the previous night. This was seen as a clear pattern, further establishing that her memory loss was not a one-time occasion. A professor of biomedical science said that her lack of memory was a fault of the memory process and possibly, but not necessarily, related to her decision-making process. Partially on that basis, the judge did not tell the jury to consider her memory loss when making their decision. Of course, her drunken state was very much so considered, but that was semi-independent of her memory loss. After the decision, Evans was not allowed to hire another, perhaps better, expert, since the jury's verdict was not based on her memory loss. As Ched Evans is sentenced, the judge says to him that the woman was in no position to form a capacity to consent to sexual intercourse, and you, when you arrive, must have realised that. That has been said to accurately reflect the verdict, as despite no signs of violence, the long-term psychological damage done to her would have been significant, and that was unaffected by her memory loss. As I said, I hope I've given you as balanced an insight to the case as I can. If you want my opinion, here it is. Drunk sex is rape. I'm not talking about one or two beers. In this case, she is clearly, visibly too drunk to give consent. That is rape. I'm really not open to any argument otherwise on this, despite trying to keep everything I said earlier in this video as balanced as public information allows me to. When my girlfriend is tipsy, I'll make sure I have more than reasonable grounds of some vague sort of pre-consent, as well as her enthusiastic consent. Any more than a bit tipsy, and I'm flat out not comfortable with it. If you cannot be certain that someone has consented to sex, you should not have sex with them. That doesn't mean them signing a legal document before you initiate foreplay, it means asking if they're enjoying themselves, so they like X, so they want you to keep going, whatever. Them not saying no is not consent. Consent is some form of clear yes. In my view, if you're too drunk to drive, you're too drunk to give consent. This is a whole world away from the Ched Evans case, where the woman is visibly really drunk. As for MacDonald not being convicted, it was made on the basis that he was with the woman for much of the night, and therefore she gave some form of, admittedly fairly vague, pre-consent. Evans was not with her at any point in which she may have consented. The idea that on the basis that he is a convicted rapist, we should somehow feel sorry for a young footballer whose career has potentially been wasted is an absurd way of sympathising with a rapist over their traumatised victim. Similarly, the idea that the poor old convicted rapist is being ganged up on seems crazy. And finally, the idea that he was only convicted because he's a footballer not only, in my view, undermines the perfectly valid decision made by the jury, but also doesn't make much sense given the perception of how likely Oscar Pistorius recently got off. Though in terms of whether he should play again, I've been on the fence for ages. Now, whilst filming, I think the idea that he shouldn't play again holds more weight, and so I support the actions of, for example, Jessica Ennis-Hill, who feels that being a role model carries huge honour, that Sheffield United re-signing him would go against that, and therefore that if he were to re-sign, she would want her name taken off Bramall Lane, their stadium, in which a stand is devoted to her. But at the same time, I do understand the other side and think it's a perfectly valid view to hold with merits of its own. But again, over everything, I hope that this video was helpful in forming your own opinion on this topic. I really don't know how to end this video. I don't want to end it with something like a subscribe or like a happy ending, because this is a really serious topic. Not only the Ched Evans case, but rape in general and how we treat it in this country. So I'll leave some helpful numbers for you in the description below. And otherwise, I hope you have the best day you can.